What is a challenge for cause during jury selection in a medical malpractice case, an accident case, or wrongful death case here in the state of New York? Would you like to learn what that is? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. A challenge for cause means that the attorney now has to give an excuse and a reason during the course of jury selection about why they do not want a particular juror sitting on their case. Now, let me explain the process. When attorneys go in to select a jury, each attorney has an opportunity to talk to the potential jurors who are going to be sitting and evaluating and deciding your case. Now, if the attorneys do not agree on excusing a particular juror, they will have to go to the judge who supervises jury selection and give the judge the explanation about why they believe a particular juror is not appropriate to sit on this particular case. Now remember, during jury selection, each attorney has 3 opportunities to excuse a particular juror without giving any reason whatsoever. And what happens if the attorney has used up all of their 3 opportunities? Those are known, by the way, as peremptory challenges. Well, if that happens, and now an attorney is talking with a potential juror, and there's something in the juror's background that simply does not sit well with this attorney, and the attorney does not believe that this juror should be allowed to sit as a juror on this case, what happens then is that now we have to present the matter to the judge who supervises jury selection and give the judge the reason why we believe this person should not be allowed to sit as a juror. So let me give you an example. Let's say we ask Mrs. Jones, Mrs. Jones, do you believe that our system of justice is fair? No, I don't believe that anybody's entitled to bring lawsuits. I think it's wrong. I think that nobody's entitled to compensation. So as the attorney who represents an injured victim who's seeking compensation, how do you think that's going to make me feel when I hear a response like that? I'm going to ask that this potential juror be excused and not be permitted to sit as a juror on this case. The defense attorney, on the other hand, would love this and would love such a juror to be sitting on the case. But now the judge will ultimately have to decide whether or not this person is qualified to sit and be fair and impartial to both sides in this case. When you hear an attorney talk about challenges for cause, what it means is that the attorney now has to present an excuse to the judge in order to determine whether or not this potential juror will be allowed to sit as a juror on your particular case. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process here in the state of New York. You know, I recognize you're probably watching this because you have questions and concerns about your own legal matter. Well, if your matter happened in New York and if you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I answer these questions every single day and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.